Good morning, audience. I shall be presenting this case and my submissions before this honorable court on behalf of the respondent in this matter of appeal made by the appellant against the judgment passed by Honorable High Court of Intra Moot in the trial of a writ petition filed by the appellant. Now, if your lordships may please, I shall bring some of the facts and proven facts related to the issue raised by the appellant. My lord, the facts related to the case are as follows, as per the questions. My lord, kindly refer to the page number 5. Some of the facts are written as below. First, the government of Bharatmala enacted the Public Safety and Data Management Act 2024 to enhance national security and facilitate data-driven governance. Second, the act mandates extensive data collection from citizens, including biometric details, location history, and online activity, stored in centralized repository managed by private contractors. Third, Section 8 of the Act exempts data sharing agreements and operational guidelines from disclosure under the Right to Information Act 2025, citing national security concerns. My lord, the fourth statement of fact is a private company, Data Locker Private Limited, was contracted to implement the Act. However, in July 2024, it suffered a cyber attack, which resulted in a loss of private data of millions of the citizens of Bharatmala. Lordship, Ravi Gupta, the appellant, a journalist whose data was allegedly leaked, filed a writ petition in the High Court of Indrapuram, challenging the constitutionality of the Act on the ground of the privacy violations. Next, my lord, the High Court upheld the Act's validity but directed the government to improve data security measures. Dissatisfied, the appellant has appeared before your learned court. Now, my lords, with your permission, my fellow counsel second would present the statement of issues before. Yes.
I would seek the permission of the honorable court to come on the bench. Good morning, Lordship. I am counsel second. I shall be representing Data Law Private Limited. If it may please, Lordship, I shall present the statement of issue as raised by the appellant regarding this case.
Please.
Thank you, Lordship. Lordship, first issue is that Lordship's first issue is that whether the Public Safety and Data Management Act 2024 violates the right to privacy under Article 21 of the Bharatmala. Second is, Lordship, whether the denial of information regarding data sharing agreement, operational guidelines, and breach protocols infringes the right to know under Article 19(1) subclause A. Third is, Lordship, whether the PSDMA meets the constitutional requirement of proportionality in balancing privacy and public safety. Third is, Lordship, whether the exclusion of judicial review under Section 11 of PSDMA is constitutionally valid. Lordship, further submission should be made by my fellow counsel representing the government of Bharatmala.
Now, Lordship, with your permission, I would like to. Your learned Lordships, as far as the issues are raised by the appellant, I must present my solution before this honorable court. As per the issue number 1, whether the Public Safety and Data Management Act 2024 violates the right to privacy under Article 21 of the Bharatmala Constitution. My lord, my submission is that PSDMA 2024 is not violating of Article 21 of Bharatmala. If you refer to the Section 3, subclause 1 of this Act, which clearly states that the government collects data for the purposes of national security, crime prevention, and urban planning. The collection of location history and online activity shall become essential due to the rising threats of digital space and growing cyber crimes. My lord, as far as the second issue is concerned, whether the denial of information regarding data saving elements, operational guidelines and breach protocols infringes the right to know under Article 19 clause 1 subclause A. However, that the right is not absolute, right to know is not absolute and can be restricted under Article 19 clause 2 of the Bharatmala Constitution for reason which is given as sovereignty and integrity of Bharatmala, security of the state and public order.
So who is going to judge whether this is within the parameters of the restriction? Because there are no parameters defined for violation of public order, sovereignty, security. Because this is something which is very substantial.
Ma'am, the interpretation is up to the learned code. Next. Ma'am, sorry, Lordship, Section 8 of the RTI Act allows for the denial of information if its disclosure compromises national security or foreign relations. If we refer to the case of Anuradha Bhasin versus Union of India, Lordship, the Honorable Supreme Court held that the reasonable restriction can be imposed in case of concerning national security. If we refer to the second case, my lord, in ADM Jabalpur versus Srikant Shukla, in 1976, the Honorable Supreme Court ruled that national security interest can override individual rights in exceptional cases. Lordship, we must refer to a legal maxim also.
So what are the facts of ADM Jabalpur case? Counsel, and how are you related the facts with this current position? This is a very old case.
Yes, Lordship, it is from 1986.
So how are you related? Because this is a landmark case on habeas corpus.
Ma'am, whenever right of a single individual has been heard and the right of many individuals are heard, the preference shall be given to maximum amount of the people, more number of the people. If data breach of single person is concerned, that shall be overseeded by the national security. Which the maxim itself says that, if we refer to the maxim, salus populi suprema ex means public welfare is the highest law. Here, my lord, welfare of the national security is also important, but as far as the public welfare is concerned, it holds the highest criteria and priority of constitution and Bharatmala's law. My lord, if we move to the third issue, whether the PSDMA meets the constitutional requirement of proportionality, equality, privacy and public safety. So, in case of, as far as constitutional proportionality is concerned, my lord, we have to go through 3 or 4 points. First, the act is brought with which aim? The aim must be legitimate. Here, the act itself declares that the legitimate aim of bringing this PSDMA Act is national security and public safety and data-driven governance. If we refer to the Section 3, Clause 1 of the Act. The Act is designed to protect citizens from threats such as cybercrime, terrorism, and urban risk. Lordship, data-driven governance enhances law enforcement efficiency and urban planning. The second test of proportionality shall be rational collection between means and aims. Lordship, collection is limited to authorized agencies, ensuring controlled access to the data. Data storage is secured and shall be deposited in a centralized manner, which shall ultimately minimize the risk of the misuse of the data. Strict penalties for unauthorized access maintain compliances.
So in this case, has erupted only because of the breach of data.
Sir, pardon?
Your repository, between the private individuals whom you have appointed, they have failed to protect privacy rights. Therefore, they failed to protect the data.
Yes, Lordship, I agree that the breach of data happened, but it is not in a generalized sense. It happens for the first time, and the government has ensured each and every measure which is suggested by the government, by the Honorable High Court of Intra Moot to further stop it from breaching. Lordship, the third test of proportionality shall be necessity. It must not be less intrusive alternative available. My lords, here due to the growing cyber space and digital crimes, we are not having any different capacity to cut digital crimes, because this type of digital crimes require real-time monitoring, making data collection imperative. The Act mandates cybersecurity measures and audit mechanisms to prevent misuses. The next proportionality test shall be, my lord, balancing public safety and privacy. My lord, here, as per the Act, personal data access is lawful and misuse is punishable under the law. There are several provisions have been provided in the Act for the punishment. My lord, the next one is breach notification requirement ensures transparency in the case of unauthorized data exposure. National security concerns overweight minor privacy intrusion following global best practices. My lord, the government of Bharatmala has done whatever it could to curtail the data breach. If we move towards the fourth question, my lord, whether the exclusion of judicial review under section 11 of the PSDA is constitutionally valid. My lord, by section 11 of the Act, we are not curbing anyone's right to present before the court. But as we can see that the appellant has already enjoyed that power of presenting before the court under Article 32 of the Constitution, when he went to the High Court of Intra Moot. Lordship, here national security requires finality in decision, because judicial intervention could delay urgent security related decisions taken by the statutory body. Because it is, it is totally specialized, it needs specialized expertise and which court may lack. Ultimately, the court has to refer to any subject matters expert, which will lead into the.
So, as per your version, you are of the opinion that the jurisdiction of this court and High Court is included under the Act.
Yes, yes, my lord. Article 32 and 226 has not been removed or.
But the law does not say so.
But Act also does not say so that you are not allowed to go before the court in Article 26 or 32. Lordship, Section 11 also expresses that it prevents judicial overload and previous challenges. As we have seen that our honorable courts are filled up already with lots of cases and are having no time to discuss all the cases or undergo trials of the cases. That's why Lordship, courts are already burdened with litigations and allowing judicial review could flood the judiciary with challenge to data regulations. Ensuring swift decision making in data security matter is crucial for governments. My next solution, shall be, my lord. There are strict penalties given for data misuse under Section 9 of the PSDA Act, which ensures accountability without the need of judicial review. Thank you, Lordship. These are some of the assessments I would like to submit before this honorable court as per the appeal made by the appellant. Thank you for listening.
In light of the argument advanced by counsel first, the respondent prayed before this honorable court. First, that honorable lordship may uphold constitutional validity of the Public Safety and Data Management Act 2024. Second is lordship may declare that the PSDMA does not violate Article 21 of Article 91 subclause A. Lordship, third is may affirm that the exclusion of judicial review under Section 11 of the PSDMA 2024 is valid. Fourth is lordship. Lordship may pass any other relief. I have submitted the prayers of the lordship.
Now, Lordship, as per the points made by our fellow counsel, I would like the court again to refer to the Section 3, subclause 1 of the Act, PSDA Act. My lord, Section 3, subclause 1 clearly said the government shall collect personal data from all residents of India for the purpose of national security and crime prevention and urban planning. My lord, it has become a necessity for the governments to collect national data because data like biometric information and location history are very important in checking and balancing the crimes and reducing, and for the better planning of the urban societies. The data collection is very necessary. The next rebuttal shall be, my lord, as per section 4(2) of this act, the contractor are directed to implement stringent cyber security measures to prevent unauthorized access or breach of collected data. My lord, here the act itself declares that the government and each of the stakeholders involved in the data collection are advised to implement stringent security about the cyber measures and further prevent unauthorized access or breach of collected data. My lord, if we move to section 4, subclause 3, the government shall conduct periodic audit to ensure compliance with data protection standards. Our fellow council put a question for section 6. Lordship, we have to refer to the section 6 subclause 2. This section directs the private entities for complying with the confidentiality and security requirements set by the government. Lordship, as far as the section 11 is concerned, section 11 of this act does not bar from going to court as a matter related to any technical field. It is necessary to be discussed with the technical experts. And a matter of fact is that the applicant has already exercised his powers of going before a court under Article 32. Lordship, my next submission shall be as per the direction given by the Honorable High Court of Bharat against the writ petition filed by the petitioner. In the same matter, the government of Bharatmala or I shall submit an affidavit and other stringent measures which are taken by the Data Locker Private Limited after the suggestions of the Honorable High Court of Intra Moot. My lords, as far as penalty is concerned, the government of Bharatmala and Data Locker Private Limited has stated that Honorable High Court of Indrapuram stated in the Honorable High Court of Indrapuram that the breach of data was a single incident and shall not happen again in the near future. And I am ready to submit the affidavit, my lord, on the given date. And obliged, I will oblige, my lord.
Sir, the Council 6 proposal is.
That's fine.
Thank you, sir. Sir, the Lordship, Honorable Lordship, the Supreme, the Public Safety and Data Management Act in Section 11 exempt judicial review, but in L. Chandra Kumar, the Union of India, judicial review is a basic structure of Constitution. And according to basic structure document, it cannot be removed.
Okay, you are accepted. You are accepted to be a
Thank you. Much less.
One minute. Final. Go on. No, sir.